May I please, sir, also. Lordship, item number 7, Lordship. Lordship, I need little bit of accommodation on this because I have been engaged today only. So I'll file the wakalat number, Lordship. Some accommodation, Lordship. 10 days accommodation.
You're appearing for
I apply for the
Ten.
conditions. Apple.
appellate. Mr. A. Colita, Learned Counsel, has submitted that he has entered appearance on behalf of the appellants only today and has thus paid for listing of the appeal after a week,
10 days time, Lordship. 10 days time.
after 10 days.
Publish it.
MS BPM, Lorenzo, is present for the state response.
Publish.
May I please, your lordship? I'd like to mention item number 5.
Five.
Can it be? Yes. Finally, this matter may be adjourned to another date.
On the prayer of Mr.
All Oscar.
Paul of God, Learned Counsel for the appellate. The cases, the appeal is also apathetic.
Like,
MS BPM, present.
with regard to item number 17, your lordship, I have the sample prayer. Today, my preparation is not complete. It's a jail appeal. May I pray for short date, your lordship? Item number 17. Next Monday, if it's convenient.
Okay, on the prayer of Mr. A. M. Doctor, Learned Clinical School for the appellant, list the case after
After a week.
MS BPM.
Must.
Lordship, I beg to mention item number 1.
One, who are you? Your name, please?
My name is S. Bashar. My name
S.
is not
Bashar.
there. I'm appearing on behalf of
On
Mr.
the-
B. Halder.
Prayer of MS S. Bossat, Learned Counsel, for Mr. B. Halder, Learned Legal Counsel. The case is passed to authority. BPM. Present.
May it please your lordship. There is an appeal against the conviction, my lord. Conviction under section 302 life. There is no eyewitness, my lord, only on the basis of the last seen together theory he has been convicted.
Uh, But two accused have been convicted.
I am
You are-
only one, only one.
Heard Mr. T.J. Mohanto. Learned Senior Counsel, assisted by MS
P. Sharma.
V. Sharma, Learned Counsel for the appellant. Accused appellant and MS B. Punya. Learned Senior Counsel and Additional Public Prosecutor, assisted by MS M. Pravodi. Learned Counsel for the respond number 1, State of Assam. Full stop. The present appeal under 374 2 Code of so and so is deferred by the accused appellant, Mohammed Rafiq Ali, against the judgment and order dated. Second, 3/2024. Full stop. By the judgment and order dated 7/3/2024. The Court of Learned Station Judge,
Basta.
Musalpur. Will you make a trial court? Two accused appellants, 2 accused persons. Mohammed Rafiq Ali, we didn't make it A1. And Mohammad Jahirul Ali. Put in bracket A2. Have been convicted for the offenses under section 302 IPC Raid with 34 IPC and
365.
section 365 IPC Raid with section 34 IPC. Full stop. Both the accused persons are sentenced to undergo a rigorous imprisonment for life and to pay a fine of rupees 2,000, in default of payment of fine, to undergo simple imprisonment for another 6 months each for the offense under section 302, IPC Raid with 34, IPC section. For the offense under section 365 IPC Raid with 34, section 34 IPC, the accused persons are sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 2,000 each, in default of payment of fine, to undergo simple imprisonment for another 3 months each. Full stop. Both the sentences are ordered to run concurrently. The appeal is admitted for hearing. Let the record for the learned trial court be called for. In the sessions case number with your sessions case number 82/2020. As MS Mia has appeared at an accepted notice on behalf of the respondent state of Assam. No formal notice. And I extra copy of the memorandum of appeal, and we can accept the findings. MS Mia within 3 working days. Any IA?
There is a, I will be pleased after receiving the record. I'll
Okay.
please.
We'll file our objection.
Yes.
If you know same applicant appellant नाम लिख दीजिए in the second change video. Notice we issued to the the net additional public prosecutor. The issue notice return for weeks shall file objection for the returnable.
Mine. Deep blue.
Item 3.
May I plead, my lord?
Offense
Offense 302, my lord, similar, almost similar, my lord, convicted for life on the ground of, my lord, last seen together, my lord. It is the same.
Extra আছে না copy? না, আমার copy না। I open a copy হলো না।
only one accused person.
Yes, my lord, only one accused person.
Please have this appeal.
Dimensions are for it. Ever receipt is-
The present appeal under
No, I
section
would-
370
like it better is, no?
Code of Criminal Procedure 1973 is directed against the judgment and order dated
Sure, no. But yeah, I-
judgment dated 9/3/2023 and an order of
Oh,
dated 13/3/2023 passed by the learned session judge, Majuli in sessions case number 40 within bracket KM 2021. So stop by the
what is it?
judgment and order, the accused appellant has been convicted for the offense under section 3
Bangalore করা, no?
Indian Penal Code and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000. In for the payment of fine, to suffer simple imprisonment for another 1 month. First of all, I feel that for reading. The records from the government trial court. We call for issue notice to return it in 4 weeks as MS Mia. As appeared next for the respondent number 1 state of Assam. No, Thank you. No problem. Notice the applicant shall take steps to the applicant steps for service of notice upon the fund number 2 by respectful to KD within 3 working days. I is there,
Yes, madam.
389 one CRPC. 89. Did you begin?
Lordship states whether it would be required by 302.
Yes, madam.
It is notices served, okay, otherwise you'll
My
Yes, madam.
dispense with.
Yes,
lord.
we have met party, madam.
Item 4. Okay, same like you want.
Yeah, please, your lordship, my lord.
Yes,
But this is a statutory appeal as your lordship is aware, my lord. So I pray that it may be admitted.
how many
also.
appellant?
Two, my lord, father and son.
So Lordship notice.
Pokso, I made the,
Last order. Direction of your lordships, I have taken a step.
POCSO matter.
Public prosecutor received notice on 16/5. We are only on
Yes, no?
20, right?
Yes,
So service of notice,
my lord.
you have
We are
to
wait.
obtain a report.
Madam.
Heard, Mr. A. Roman,
My lord.
learned counsel for the applicant appellant and MSB Mia. Learned senior counsel and additional investigator for the respondent number 1, Kama State Council.
Like this is a copy.
From the
State population man. Steps two.
dated 16/5/2024,
Steps two. Nazar
it is noticed that Office of the Public Prosecutor, Guwahati High Court, has received the copy of the notice on 16/5/2024. Post office. MS Bhuyan. Learned additional public prosecutor has sought for listing of the case after 2 weeks in order to obtain a report as regards service of notice upon the respondent number 2 from the officer in charge, Dhubri Police Station. Objection filed already.
Lordship, he said
My lord. Long way.
somebody has dealt with the matter, no? Ms. Jahan.
A written objection will be filed.
Right.
Okay, get the report.
Lordship, I'll get.
Release the case after.
Obliged.
Okay.
Sapna. Lordship, we have sent our intimation through WhatsApp also, Lordship, to the concerned PS.
Report received.
That is not received, Lordship.
Oh,
Yes. Along with the
But
order copy.
it was on 5/4.
Yes, Lordship. And we have taken.
Your name please, S. Sharma.
Yes,
S. Sharma, applicant appellant, Update Bora. Firuza office note dated 5/4/2024. Posted. MS Bora. Learned additional public prosecutor for the opposite party as respondent number 1 has sought further 2 weeks time for obtaining a report as regards from the officer in charge, Moriani Police Station, as regards service of notice upon the respondent number 2 stroke informant stroke opposite party number 2. Stroke informant stroke victim. So please the case after 2 weeks for report on service of notice from the opposite party number 2. Stroke
Obliged.
informant stroke victim.
obliged.
Call for the case there.
Lordship.
LCR has not been received.
Subject to correction, Lordship. If I remember correctly, Lordship, this is an appeal against rejection of bail. Now, in the appeal, Lordship has to consider the bail. This is an appeal against rejection of bail
Bail,
by the NIA court. Now, on appeal also, Lordship will be considering the bail only.
Huh.
In the appeal, in other words, is a bail application, Lordship. If I remember correctly, Lordship, last occasion, CD was.
case diary. That is what they are timing it as case in the office note. Records are called for, not record actually, case diary.
Yes.
Court has said case diary.
Court has said case diary. Perhaps it is reflected as LCR.
So it is before charge sheet.
Charge sheet, yes, charge sheet.
Before charge sheet or charge sheet?
He has been charge sheeted.
Charge sheet.
Accused have been charge sheeted. The trial is going on.
Oh.
But while considering since trial is a different aspect of the matter, Lordship will be considering the material still the charge sheet is filed. Therefore, the CD was called for, Lordship. But I am told, Lordship, the IO was not there. If your Lordship will fix it in the next week, Lordship, by then I scan copy of the.
Case diary. Can copy of the case diary.
Yes, Lordship.
You are MS Gosal.
Jay Singh for Lordship,
Huh?
appearing on behalf of M. Biswal.
A
Jay Singh for,
Singpo.
yes.
MS J Singpo Learned Council for that. You are. There are two appeals.
Both arise out of the same
Same.
NIA case.
For the appellants. And Mr. R.K. Dev Chudri. You'll be
For one,
UI as CY or Benigam?
DYHA, Lordship.
Deputy Solicitor General of India, which is led by Mr. D. Bhardwaj. Standing outside. Learned Public Prosecutor. NI. By the order dated 6/5/2024. Passing. Email appeal number 123/2020. Scan copy of the case diary was called for. Post of both the appeals. Criminal appeal number so and so and criminal appeal number have arisen out of the same case. Mr. Dev Chudri, Learned DSDY, has submitted that. The IO brackets had some difficulty in the interregnum and the scan copy of the case diary could not be produced. He has sought for listing of the appeals after a week. Also, list the appeals again on. Third of June. 3rd of June.
Take a second. Lordship.
There is no case not filed.
May it please your lordship.
No objection to file some.
Yes.
Here in this case, lordship, that main allegation is that this five applicants,
Offense is under
302. But here two legal issues are involved here. Lordship will find that first, my submission here before your lordship would be that in the present trial was conducted in absence of public prosecutor. That your lordship may kindly see that page just I'm referring to 106 of paper book.
the paperwork is ready.
Yes.
I have not received the paper. I have not received the paper.
You have not received. You are
That-
handicapped or what?
Lordship, today is
You are
for I,
handicapped?
today is for I have got the
I can
have filed
submit
the
from
objection.
my interlocutory application also. I have enclosed all the documents therein also, lordship.
No,
This is
I meant
the
Gaurav, what
copy of
is
the
your-
judgment.
What is your submission?
Lordship, today he has moved the IA perhaps, Lordship,
Oh, yes.
and we have already filed our objection.
106 page, your lordship will find for
Can it
state
be?
none.
Who has then examined
No,
the
that
prosecution witness?
the trial court lordship. That
Who
it
had
is
examined the prosecution witness?
trial court lordship. That the presiding officer himself. That your lordship will find that just I'm referring to PW2. He is the witness who was present along with the deceased. He became hostile. Then the presiding officer put him question, lordship. He was not declared hostile by the prosecution because there was no public prosecutor. So the trial court himself put some questions to him. That your
That is
lordship-
permissible.
that is permissible. To show that public prosecutor was not there, therefore I am placing for your lordship. Page 19, your lordship will find.
No, that can be done. That can be done.
That can be done. Just I am showing that public prosecutor was not present
But
because he
then
was,
the public prosecutor is not available.
yes,
He is not
that
conducting
order,
the
or-
prosecution.
order
That is
sheets,
serious.
yes, order sheets are there. Your lordship will find that charges were framed on.
Then this is
Twen-
a serious issue which then it will require the main appeal to be heard if
Yes.
this trial is vitiated
Yes.
on that count.
Order dated 22/02/2022. Here said 25 and 26 is there,
One
lordship. 225.
The order of framing search,
Yes,
page number,
that is the record, lordship, order. Order dated
It is not-
22,
paper book.
not part of paper book. Lord.
Because 225 specifically says.
Yes.
In every trial before a court of session, the prosecution shall be conducted by a public prosecutor.
Shall what is there?
It cannot be done by additional
Yes.
public prosecutors.
And 226 is also there.
Hmm?
226
Opening,
opening.
Hmm.
that is opening then every stage,
Yes.
Yes.
at the stage of framing of charge.
Hmm.
That is there after hearing perhaps, 227. After hearing the submission of the accused and the prosecution,
Yes.
227. Order sheet.
Order sheet.
Let's see what it is.
Charges were framed on 22 February 2022.
Charges were framed on 20.
2 February 2022. Second,
Public procedure is absent. Then in the same order, that public prosecutor has not been taking steps for summoning witnesses.
Just
What
when-
the heck? That's okay. 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 Is there any observation in the judgment?
yes, in the observation, in the
In the
judgment, judgment, it is simply said that during argument, he was not there. And in page 106, your lordship will find
Of your,
paper book, lordship.
of the paper.
Yes. 106. Name of council.
I have seen it already.
Yes, and then your lordship may kindly turn to,
In the judgment, anything
yes,
observed?
yes, paragraph 3, your lordship may kindly see.
Internal page.
7. Paragraph 3.
No, his absence has been noted somewhere. His absence.
In paragraph 3, it is there, at the time of argument, none from the side of the state was present.
Which line?
The
Okay.
first line paragraph.
Paragraph.
But about
About evidence, lordship, that I have already placed your lordship, that order sheet shows that in the framing of charge, it is not there. 313 was recorded, that is not, public prosecutor was absent. Page, order dated 6/12/2022.
Hmm, 6/12.
22, lordship.
Framing of charge, PP was not there.
Not there. 313, he was not there. Argument, he was not there. And order sheet is silent whether he was there when the evidence was recorded. That is the case.
The question is agreed that the PP was not there.
Lordship.
So would it amount to? No,
Yes,
would it
Lordship.
vitiate that? Right?
Yes, I have got one judgment from PV Council, Lordship. Apart from that, there is no judgment on the issue here. And it says
Oh,
it will
very good.
vitiate, Lordship.
Okay. MS Bora, can you ascertain that during that period, there was no PP at all?
Lordship.
MS Bora can ascertain,
Yes.
right?
Yeah.
Right.
Mm.
If in the in, before the session judge, because PP has to be appointed.
Yes.
PP was not there. Have you collected any information?
Yes, I have talked with the trial court lawyer. He said he was not there, and even
No, he was not there is one thing.
yes, the
and
PP
he-
was not there.
PP was PP was existing.
That specific, I have to take
No,
instruction.
one thing is that PP was not at all in the,
Lordship,
not, there was no PP appointed. suppose.
Lordship.
Then it is a completely different thing.
Then in that
Then
case,
another one is that PP was there, but he was not conducting the
Lordship.
proceeding.
Yes.
That is another one.
another aspect. That
The
instruction.
PP was not appointed at all,
Yes.
but because I think trial could take an active part,
Lordship,
but cannot conduct the prosecution.
Lordship. And in this
Because
regard,
the nature of writing evidence,
It's a matter of in the.
nature of writing, he has, trial court has paragraph wise
yes,
recorded.
Record.
That is some notable thing.
Lordship occurrence took place in the year 2020. That is the COVID time, Lordship.
that may
Whatever.
be. And one notification of our High Court is there. I can place on the next date. And that says, Lordship, there was a meeting with the district judges and our High Court, Lordship.
Ah.
And in the said meeting, it was directed to the district judges that if the public prosecutor is absent, you should inform the district magistrate, and accordingly the procedure was there. I can place that notification.
In the absence of PP, additional public prosecutor can also. appear.
Yes, certainly they can.
Twenty-four. 25.
Ah. For that is. Cell. The public prosecutor cell open that is the ID. Huh. The prosecution shall be conducted by the. Yeah, the one. Additional public. Additional public.
Okay, what is PV council?
Paragraph 9, Lordship, first your Lordship may take up paragraph 3. What was the issue there? Paragraph 3, your Lordship will find. The question which arises for decision on this appeal is. Lordship,
Paragraph 3.
Paragraph 1.
Ah.
The question which arises for decision on this appeal is whether the trial of the accused was vitiated by the failure of a prosecutor to appear at the trial and by the course which the trial took in his absence. After discussing those provisions, Lordship, that 226 is same as in present act, Lordship.
1 minute, definition of public prosecutor,
Yeah.
1 minute. But what is, it is from Somali or what?
Lordship,
From Somaliland.
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 Paragraph 9 is the finding.
It may not be so factually applicable. Somali CPC may be different, CRPC.
The 226 is same, the 226 present and
Please
220. That is in paragraph 4, your lordship will find that 226 is quoted.
Yes.
Paragraph 9. The absence of a prosecutor necessarily involves a breach of section 226 of the ordinance. Since he could neither open his case nor examine his witnesses. It is to be observed, however, that the definition of public prosecutor in the ordinance contemplates that there may be a prosecutor other than a public prosecutor regularly appointed by the governor under section 356, and their lordships cannot think that there would have been any other overwhelming difficulty in securing the service of some suitable person as prosecutor, and thus avoiding the acquittal of the accused for lack of evidence tendered against them. That course was not followed.
Yes.
That course was not followed, and the judge himself undertook the duties of prosecution. This was the real vice of the trial. Breaches of particular provisions of the ordinance might have been cured under section 393, but the combination in one person of the duties of prosecutor and judge in their lordship's view prevented the trial from being one conducted substantially in the manner required by the ordinance. The accused did not have the protection to which they were entitled under the ordinance, namely, to be tried by a judge whose mind was not and could not have been affected by assuming the duties of a prosecutor. The curative provision of section 393 of the ordinance, which is expressed in substantially the same terms as section 537 Indian Criminal Procedure Code, cannot be called in aid to support a trial conducted in a manner substantially different from that laid down in the ordinance. Their lordships have no doubt that the trial judge did his best to be scrupulously fair to the accused, but it is impossible to be sure that a judge who himself examined the prosecution witnesses escapes an unconscious bias in favor of accepting their evidence. The judge rightly refrained from cross-examining the defense witnesses, but it would be difficult for him unconsciously to avoid discounting some of their evidence on the ground that it might have assumed a different aspect if subjected to cross-examination. The chance, perhaps a small one, that some witnesses might have impressed their veracity upon the court by the manner in which they stood up to cross-examination was lost to the accused. It has been said many times that it is necessary not only that justice be done, but that it may be seen to be done. The accused and their friends can hardly have felt assured and impartial justice would be meted out to them by a judge who was acting as prosecutor. Reference was made to so. We have examined the prosecution witnesses in absence of a prosecutor, but that case was tried by a jury, while in the present case, judge himself had to try the case. For the above reasons, their lordship felt that it is necessary to advise his majesty conviction and sentence passed upon the appellant be quashed and they be acquitted.
The first PW one
One.
was examined on which date?
20 April 2022. 1 to PW 6 were examined on same day.
When is the last
Last was
PW?
9.
PW 9. He was examined 3rd of December 2022.
Before recording anything, do you have any information whether there was appointed PP or not? Say on 28th April 2022.
That I have.
Can
to
you
take-
get the information? Then we can put it in the order to obtain instruction through MS Bora. Then if the evidences are recorded without a public prosecutor, then that thing may assume different proportion, right? That is what we want to know. So can you get the instruction from your associate there that whether during that period uh, there was an appointed PP or not,
That I will.
right?
Lord,
And secondly, if there was appointed PP, whether he was present on those dates or not. And what is the procedure for
Lordship may
if
direct that.
PP is before the session judge? Whether he has to file any memo of appearance on each date. That is what is also important.
That
What about the first? And it is also interpreted after that. Okay. And what is the permissive mode for interpreter
that interpreter, your lordship will find in the
in the
evidence
CRPC?
in CRPC, lordship just is there, lordship 275.
275.
Interpreter lordship 282, sir, lordship 282.
So there is a duty of the interpreter.
Interpreter. And in Evidence Act 119, your lordships will find
Even in. Even.
In case of different.
1-1?
119.
9. Better interpreter.
Provide the videographs to you, provided.
Yeah, the circumstances. Yeah.
Then there is one end, such statements will be videographed.
Yes, that videography should be there.
11th section. That was brought in 2013. No, that is, if the witness is unable to communicate verbally, he can communicate,
Yes.
but language is different.
In respect of.
So this proviso will not come.
But here your proviso, your lordship may.
Proviso will not come because unable to communicate verbally.
In case of
If- if-
defender,
It is dumb.
Dumb.
It is dumb with, then videograph.
But the,
Then because the man
Right.
who will interpret all these sign witnesses, he may interpret on his own.
Hmm.
So that is why this is to be preserved. But so far as
you can speak.
witness who can speak, everybody will be hearing.
that,
So that protection is not there. But who is to be an interpreter?
that provision I have not.
Can the benches be an interpreter?
That I have tried to find out yesterday, but I could not find
Uh-huh.
it.
The a few
Yes,
issues.
that,
you
that
come
is,
up with
therefore I
some
said,
answer.
lordship, that legal issues are here. That,
Ah.
that is what I found it out.
With an answer, whether he can.
But I didn't know how I put it.
Find out any judgment on 225 CM.
Not sure. So it says it's
That,
a-
except that there is no other judgment I have found, because the same issue I have argued in court number 7 also. The court number 7 also said that the research team could not find any other judgment except this one.
Directly may not be there, but indirectly the same may be discussed. in
In
some
the
other
indirectly,
judgment.
recent judgment of Honorable Apex Court is there, where Honorable Apex Court said that we have forgotten 226. It is a mandatory provision. That passing remark is there, I can place that judgment.
Whether suppose there was no appointed PP, then it is completely different.
Yes.
In that case, that notification of our High Court will come to play. Lordship,
What is the
because
notification?
that I will place on the next day for you.
Vivaha copy of that.
And in fact, on merit also, I have a case. Lordship, that in cross examination, the PW2 was the only person who was accompanying the deceased. In cross examination, he clearly stated, and even court asked him, and he said, I was drunk, so I named the present applicants. I do not know who has caused this. Apart from that, there is no material to connect these applicants.
On behalf of one, the pilot section of. File code बोले खोलेंगे
Have you consulted AIR manual? AIR manual. There is series 40-50 volumes. AIR manual. Find out from that. On 225,
225.
226. Plus, get the information whether there was any appointed public prosecutor on that day. If no public prosecutor, then court has assumed a role which should not have been assumed.
Yes.
But if there was appointed public prosecutor, but by his negligence, he did not take part in the trial, that is a different issue. Then we'll hear on the point, on the merit next Monday.
Yeah, sure.
You
Get
can
the
also obtain
information.
instruction, that will be easy for her, Lordship.
No, the first you get
Lordship, I will also
Lordship.
try to.
that there was any appointed PP
Right.
during that time or not. The trial
Right.
lawyer will be having
Appoint-
that knowledge.
Regarding appointment, I will have some difficulty to obtain instruction because whether about presence, I can obtain instruction.
No, find out
Lordship, I will
that
try.
trial lawyer might be knowing.
Lordship.
During that time, there was no PP at all.
Lordship. I will try.
It happens sometimes.
Lordship.
No. Should not very specific.
কেতিয়াবা তো পিপি বেমাৰ ইভাগে তাতে তো পিপি কৈছে তাতে তো কথাটো ক্লিয়াৰ হৈ আছে উইদাউট পিপি নিজে লগা অ
So it went on like this. PW2 converse in Boro language. The bench assistant then translated it to Assamese.
Assamese.
And then it
Then
was translated to
the,
English.
the trial court
Yes,
had converted into English.
English.
Many things.
Many things.
And this part, page. People have-
কেতিয়াবা ধৰক কিছুমান ডাউট থাকিলে কৰোঁতে ওৱান ছিক্সটিন
Find out on those dates. 20/04/2022 and 29/4/2022. 5/5/2020. Lastly, IO. 3/12/2020, right?
No.
Find out. At least from your side. Then I'll ask whether then if there was no appointed PP at all, then I'll ask whether actually there was no PP. There must be something. If additional PP is assigned, suppose, there
Yes.
must be something.
Yes.
And find out from air manual if there is anything on 225, 226. Also regarding interpreter.
ইণ্টাৰপ্ৰিটাৰটো সাধাৰণতে ইম্পাৰ্চিয়েল হ'ব লাগে কিন্তু কোৰ্টৰ
Have you consulted? No, no, I can't. I don't know. I could do this. Email them.
And in respect of lordship,
No?
in respect of exam, cross-examination of PW2 lordship, that was not done on the same day. And there is
I
a
have-
bloating lordship, yes.
That I have.
Page 33, internal page lordship, the judgment.
1 to 6, pick it up.
Find out on the next Monday. But it's very, learning for the applicants, appellants, and MS. As a for all learning additional public prosecutor for the respondents to the some. In the it appears that in the trial, in the sessions trial, we got a lot of trial from the charges were paid in absence of the learned public prosecutor. And the final argument was also heard in absence of the learned public prosecutor. Learned counsel for the parties have sought listing of the case after a week in order to obtain further instructions. Also, place the is on next month.
Lordship,
Mr. Bora, you please
Yes.
also find out,
yes,
is there anything
yes,
appointed public prosecutor or not
yes,
during that time?
yes.
57.5.
Obliged.
Yes.
Made zeros. Here also I have filed second application for suspension of sentence. They have not filed their objection yet.
Okay.
Last time. Oh, that is so. 13. No?
Part Mr. Yeah, I mean. Learned counsel for the applicant, appellant. Here, you were there?
Yes.
Okay.
It was rejected earlier, huh?
Yeah,
By another bench.
there is no bar. Oh. Okay, okay,
One of the judges.
okay. There is one issue there. Bail is to be heard at
By
least
same
if
bench.
one of them is there. Did not.
That specific notification is not there. I have searched.
Just.
Or it is says any bail application, that whether that will applicable in criminal appeal or not, that is not there.
No, no. Ultimately, it is suspension of sentence, bail. Something has been adverted to on merits perhaps.
If your lordship observe that part, then it will be helpful, because in single bench also I have raised that issue and I was told that there is no notification, so that
There
matter
is
will be.
notification.
That observation may be there, lordship, that.
এই যে এটা যে কিবা এটা যে আমি অলপ observe কৰিছিলো যে এটা যে আমি এটা observe কৰিছিলো ন notification বোৰ চাই পেলাই অৰ্ডাৰ আছিল ন অৰ্ডাৰ এটা আছিল
Same bench.
Zetkamer appeared. Zetkamer appeared.
Yes, madam.
You were there or Nia there? Nia was,
Nia, more than.
and we observed and finding out all the notifications.
Lordship,
Then, because none of us were there,
lordship.
but another or or another judge is available.
My lord.
Out of two, one is
One was
available.
available. My
One is presently available.
My lord.
So that is, we observe that I think that is to be placed before the
Chief
Honorable
Justice.
Chief Justice on the administrative side to constitute.
My lord.
Yes, then that has been done.
Right.
Like the same. But there the appeal was the rejection of bail by Nia court. Then appeal was preferred.
Earlier also we have seen that after rejection, if you file second application, it is placed before the same bench. And that notification also says any bail application.
No, if the matter is otherwise ready for hearing, then we can go for hearing.
After fourth, any date may be fixed. I'm
For hearing.
by keeping this pending, otherwise I will.
Okay, I'll keep it this. Okay.
Lordship, if we proceed with the instant bill application, then we did not file any objection, no?
No, no, hearing was fixed.
No hearing, then he cannot again praise for the bill application. Then we'll not get the opportunity to file objection.
Then this,
If he doesn't praise it, then it would go, my
no,
lord.
then see, for considering this bail application, it will go,
Before,
might go before
Yes.
banks,
my lord,
which is not regular.
lordship,
Yes.
But so far appeal is concerned,
Yes.
there is no bar for hearing.
yes.
Yes.
Then I have to again have to
Then it
take
will
time,
create a different situation.
my lord.
For appeal, this
Yes.
application, it will go before another
Different-
bench.
Yes, my lord,
For hearing the appeal, there is no bar for this bench to hear that.
my lord. And he may not. press for it
No,
as
they
an IA form.
keep it pending,
Yes, that may.
Then
keep
we'll
it.
have to file our objection,
otherwise this is a notification.
my lord. We have
Oh.
not filed our objection, my lord.
To file our objection, we have to
It's our,
proceed with the IA, no?
my lord.
Then we have to pass that order. Have you
No,
understood?
No, I understood. Then later on, if he
Or-
praises the application of IA, my lord, then
You file it
we file it, lordship.
without asking for, you can file it.
Yes, my, we'll file.
But if I observe, then before that I have to observe something more.
Yes, my,
Have you understood?
sure. I have copy to give you.
There is no bar for you.
Yes, my lord.
It is there in 389
389.
itself. Copy
Yes.
has been served to you.
Copy, no copy, my lord. Might have been served on the office.
I will serve
As
extra,
per
extra.
389, copy is to be served.
Yes,
And without the court asking for
yes, yes,
public prosecutor can file an
yes,
objection.
yes.
Why don't you file an objection
Lordship. copy.
without any observation from the
My
court?
lord, my lord, we'll file.
Otherwise, that observation is to be preceded by some more observation.
Yes.
Have
Lordship,
you understood?
my lord.
But there is a notification. It is there. It is there. In case of division bench matters, when one judge is still attached to this high court, before the division bench, if available comprising of one such bench, otherwise before a division bench as constituted by the honorable. Speaker. It is there. What is the otherwise case?
Yeah, conviction under
The background is the
6 of POXO Act.
date of birth and Mr. U. Chaudhary. Yes. Learned legal aid counsel for respondent number 2. As the paperwork is ready and all the respondents have appeared. As both the respondents have appeared, place the case field on 10/6/2024. An application under section 389 CRPC is filed by the applicant, appellant. Full stop. The said application will be considered in the event the appeal is the appeal could not be given, cannot be given final consideration, right? Lot will observe like that. MS. Punya. Learned so has submitted that a copy of the paper book is not available. There is supplementary paper book also.
Yes, my lord. Yes.
Huh?
Main and the supplementary.
And the supplementary paper book are copies, are not available at the office of the public prosecutor.
It was shown, it received by one of our, but not provided to us.
Okay. Could not be traced out at the office of the public prosecutor. Post of the office to furnish copies of the paper book and the supplementary paper book to the office of the public prosecutor. To MS Mia, so within a period of 1 week from tonight.
Obliged.
And release on bail. This is has come for first time.
First time,
Yes.
I feel to some. Offense
302.
Offense under 302, my lord.
302. You're not taking steps by usual process in the appeal.
My lord, perhaps.
You have not taken the steps for service of notice upon the respond number 2 by the usual process.
That I have to.
That is the
That I have to. Otherwise, my lord, through police direction was there to serve the notice, so police.
both by both.
Yes.
Yeah, that is the observation. You take steps and in the meantime,
My lord. My
and
lord,
will
perhaps-
issue notice in this case.
Yes.
Lordship.
Appeal will issue.
Otherwise, my lord, the appellant seems to be, my lord, truly innocent, my lord. Based on a dying declaration which was not exhibited.
Will not
Either-
go into the merits today.
my lord.
Record received. Appeal will issue. Part Mr. B. Borua, learned counsel for the B. Borua, learned counsel for the appellant. And MS S.H. Vora, learned additional public prosecutor for the respondent state of Assam. Good stuff. Mr. Borua, learned counsel for the appellant. Has sought for 3 days time to take steps for service of notice upon the respond number 2 by the usual process. Okay. As notice is also issued to the notice is also issued for report notice is also issued. Appellant has taken steps for service of notice upon the respond number 2 to the officer in charge, Rangajao Police Station.
Only on 17/5.
Okay. And the same notice has been issued to the officer in charge, Arangaza Police Station, on 17/5/2024. And the additional public prosecutor shall obtain a report
Yes, Lordship.
from the officer in charge, Arangaza Police Station, as regards service of notice upon the response number 2
Lordship.
on or before the next. As the records of the learned records of sessions case number 28/2015 case records have already been received. Command office is to prepare the paper. Get to admission. The application from I heard Mr. B. Borua, learning counsel for the applicant appellant, and MS S.H. Bora, learned additional public prosecutor for the opposite party number 1, state of Assam. This is an application of section 389, CRPC, seeking suspension of the execution of the sentence passed against the applicant appellant and for his release on bail. Full stop. MS Bora, learned additional public prosecutor, has sought for and is granted
3 weeks time, Lordship.
2 weeks time to file objection to the instant application. Full stop. After the critical is the totally critical list. The case of after 2 weeks time, the date may be. Obliged.
Lordship, one of the IE was withdrawn by them on 8/1/2024. They have preferred a new IE.
Yes, yes, new way only for appellant number one,
One.
only for appellant one.
What happened to the others?
Others, my lord, they have already taken back.
And
Given.
what to do?
Lordship will file an objection,
Earlier order already
No,
reflected.
no. In the appeal first.
my lord.
Mr. Ahmed has said that brief has been taken back from him by the appellant number 2, 3, and 4.
Yeah.
Only he will represent
One.
appellant number 1.
One, Quran
Oh,
Ali.
So in such situation, what is to be done? First,
Yes, already.
as an officer of the court,
Lordship,
Yeah.
will amicus be appointed?
do you have any no objection in your position or not?
My lord, I have given already no objection, my lord, to the,
Have you received a copy or not with you?
my lord.
You have given no objection, but while taking back the brief, whether they have,
And
will
newly engaged
later
or
or
not,
not?
I have no knowledge, my lord.
how can,
My lord, I have no knowledge, my lord, whether
can
they
you-
are engaged or not, my lord. Other-
no, that is not. You have given no objection.
Yes,
At the same time, you also keep a copy that
Must I copy?
yes, my lord. I have the
whether-
copy, my lord.
you have the copy or not.
My lord, right now,
And it has to be informed to the registry, my lord. For
already last. order, my
deleting
lord,
their name from the
I
book.
have observed
Yes.
your submission,
Yes,
but something tangible is there or not?
yes,
Like-
yes, yes, my lord. I have a copy, my lord.
You should have been at least placed,
Next to the.
make an application before the registry,
Yes,
along with a copy of that,
yes, my lord.
right? That will facilitate, then we can issue notice to them at least.
Lordship,
If they do not respond,
my lord.
then we can appoint
Point.
amicus, because we'll be handicapped to hear the
Right,
appeal in the absence of the appellant.
Yes,
Yes,
your
ma'am.
lordship.
Somebody has to be appointed.
Yes, ma'am.
And I have-
Otherwise, our judgment will suffer.
My lord.
Is it not?
Yes. And my lord, in my, I, my lord. my lord,
এইটো হেৰি কৰি লওক, settle কৰি লওক।
So you please submit an application. Along with the.
Tomorrow I will submit.
Huh? First we'll decide on the appeal first.
Yes.
First, Mr. A.M. Ahmed, and counsel for the, counsel, for the appellant number 1 and MS P. Bhuya, learned senior counsel and additional public prosecutor, assisted by MS M. Chakraborty, learned counsel for the expert number 1, state of Assam. Full stop. Mr. Ahmed on 22/04/2022 had submitted that the appellant number 1, the appellant number 2, and the appellant number 4 had taken back the brief on the informing him the region that they would make alternative arrangements. Full stop. And has appeared on behalf of the appellant number so till date. Full stop. As Mr. Ahmed has stated that he will intimate the registry about the same by submitting an application within 3 working days from today. Full stop. List the appeal after 3 weeks. Full stop. I heard Mr. A.M. Ahmed, learned counsel for the applicant appellant. 302 only,
Oh, lordship,
IPC, no POXO.
No, 302 months.
302/34,
Huh?
302/34.
302/34. Applicant, respond number 2 is required to be served.
Lordship,
I
formal notice may go.
applicant appellant and MS P. Bhuya, for the opposite party number 1, that state officer. First of, this is an application under section 389 CRPC seeking suspension of the execution of sentence passed against the applicant appellant and for his release on bail. Post of issue notice returnable in 4 weeks as MS. So it's appeared accepted. No formal notice. The learned counsel for the applicant appellant. The applicant appellant shall take steps for service of notice upon the response number opposite party number 2. That's informing
Informant.
by registered post with ready within 3 working days. The learned additional public prosecutor is to file objection to the instant application on or before the returnable date.
Lordship, I will stand corrected, my lord. Accused Ramjan, Quran, Ilyas, Yusra, and one more, my lord, are convicted under 450, 302, 323, 34. And each of them are sentenced. I said only 302, 34.
I have not recorded anything.
Right.
IPC offenses,
Lordship,
Yes.
no POXO.
my
No books. Okay.
On hearing item number 16.
Please, your lordship. Lordship, this appeal is against judgment and order dated 12.
A bit louder, Ms. Devi.
Yes, Lordship. Lordship, appeal is against judgment and order dated 12/6/2017, passed by in session case number 46 of 2012 and under section 302 of IPC by the session judge Karimganj. And Lordship,
Conviction is 302.
302, Lordship. And in this case, Lordship, 9 listed witnesses were there, but only 7 were examined. And
7 PWs.
7
Bit
PW
louder, Ms.
7
Devi.
PWs, Lordship. And Lordship, first
Where is the FIR?
FIR is at page 4, Lordship.
Okay, let us read.
Page 4. Humble submission is that around 8 a.m. today, a local, Mananuddin by name, came to my house and informed that around 12:31 p.m. yesterday, that is on 29/1/2015, the aforementioned accused had cut his wife with a hoe inside the house and that the dead body was lying inside the house of the accused. Immediately after that, I went to accused person's house and upon finding the dead body there, I informed the police of the matter. And
FIR was filed on which date?
was filed on 30/11/2015. That is next day, Lordship.
30/11.
Yes. And the incident took place around 12:30 according to the
10 PM.
informant.
10 PM. 8 AM today. So it was in the night intervening 29 and
29.
30.
30, yes. And thereafter, Lordship,
Mananuddin, Mananuddin is examining.
I say local Mananuddin informed the informant.
Mananuddin is examined.
Mananuddin is
Not examined.
not examined, Lordship.
Not examined.
Not examined.
Abdul Mannan, PW5, Lordship.
Huh?
He's Abdul Manan.
Is
but
Abdul Manan.
Yes.
He's not Abdul because Abdul Manan, he has
Huh?
denied that he has not informed.
Other Abdul
Let us
Mannan.
see then.
Abdul Manan is at his
Five.
PW5, page 16, Lordship. So may I read, Lordship? I know the accused and I also knew his deceased wife,
No, you read PW1.
Peter. Yes.
Is informant.
PW1 is called, Lordship.
Huh?
Yes,
Mohammed
PW1.
Ali.
Muhammad Ali. Muhammad Ali.
Informant.
Informant, Lordship. I know the accused. He is from our village. About 6-7 months ago, one morning at around 8 a.m., Abdul Manan,
Oh, he's Abdul Manan.
Abdul Manan,
PW5.
Yes.
yes. Abdul Manan from our village came to me and informed me that the accused killed his wife on the previous night. I immediately went to the accused person's house. I saw the body of the victim. There was a head injury with blood oozing out. The victim was lying dead. I informed the Rotabari PS and the police arrived. I lodged the Ejahar with the Nibia watch post. Exhibit 1 is the fire. Exhibit 1-1 is my signature. The police took away the body. The accused person's brother and children were also in the house at the time when I went there.
Right.
Then, of course, I did not witness the incident. So it is hearsay. He has not witnessed himself.
Okay.
Then, Lordship, I'll take to PW2. So PW2, Lordship, is the daughter of the appellant, Lordship. Page 11.
Yes.
The accused Abdul Sukur is my father. Jamila Begum is my mother. About 7-8 months ago, one night, I was sleeping with my parents and younger brother. Suddenly, I woke up to the sound of a commotion. I heard my father and mother screaming. My father asked me to call here it will be uncle, I think, Subuddin, whose house is on the top of the same tilla as our house. When I returned, I saw my mother lying on the ground and my father was standing. At that time of midnight, 2-3 people arrived, while in the morning, many people assembled. I offered water to my mother. At about 3 a.m., she died. My mother had injuries on her head. The magistrate recorded the statement. Now, at this stage, Lordship, the PWT has declared hostile, Lordship. This witness is declared as hostile on the prayer by the PP, and the PP is called to cross-examine the witness. It is not a fact that I have stated before the police and magistrate that on the night of the incident, when I woke up, I found my father assaulting my mother, and she was writhing and trembling in fear. I went and called my uncle, who came and rebuked my father. It is not a fact that my father killed my mother and I had given false evidence to save my father. Then cross, I have not stated before the police and magistrate that my father killed my mother. I am illiterate. The police and magistrate did not read my statement.
No, the guy who spoke for the vote, yeah, independent career to support. It's like.
Yes.
So, Lordship, next I come to PW3 at page 13. Is the brother of the accused,
Sahab.
the appellant, Lordship. The accused is Sabuddin. The accused is my elder brother. His house is on the same field beneath my house. About 7-8 months ago, one midnight at about 1:30 a.m., while I was sleeping, my niece Rohima, it's PW1, PW2, Lordship. Rohima came screaming to my house. She informed me that somebody entered into her house and assaulted her father and mother. I went to the accused person's house and saw blood oozing and of the victim's head.
Whether accused had any injury on his body?
No, Lordship, that's not there.
No.
Blood oozing and of the victim's head, and she was lying. The victim, Zamila, was the accused person's wife. The accused was standing dumbstruck. He asked me not to worry. The police seized one blood-stained spade and 2 sticks. Exhibit 2-1 is my signature. This witness is also replied hostile, Lordship. Then it is not a fact that I have stated before the police that on the night of the incident, Rohima came and informed me that her father killed her mother. Then the seized spade is not in the court today. I did not witness the incident. Other people visits the accused person very often. Victim family members also visit them. Jamila's father's house is about 15-20 kilometers away from accused house in Durlabchara Tea State. Nobody from the victim's house came to accused house except the victim's elder brother came but left before burial. The victim's children and wife are at present. So this is PW.
Victim's children, wife, how can this
Yeah.
wife is wrong? Yes,
Then Lordship, I come to PW4 is the medical officer, Lordship. Dr. Zakir Hussain Lashkar. On 1/12/2015, I was walking as, and here Lordship, I just refer one thing, and the deceased blood stains, spade and these are not sent for forensic, Lordship.
Huh?
Forensic report is not there. So I come to page 15, Lordship. On 1/12/2015, I was working as senior an HO at Karimganj Civil Hospital. On that day, I conducted post-mortem examination over the body of one Jamila Begum, age 45 years, female. She was brought by police constable Nishikanta Rajkumar and identified by one Sahabuddin. On examination, found the followings. External appearance, an average built female, age about 45 years, whose rigor mortis present, eyes closed, mouth closed. Then one incised wound of size 5 inch into 1.5 WX, that Lordship don't understand. Bone depth seen over the right frontal parietal region of scalp. So there were injuries on the scalp, Lordship. The bones underlying the wound fractured and the brain matter seen coming out through the skull fracture. Then another one incised wound, bone depth seen over left knee joint. And rest is, and the doctor opinion is on the last part, Lordship. Opinion. In my opinion, the death was due to hemorrhage and shock as a result of the injuries sustained. So Exhibit 3 is my post-mortem report and Exhibit 3.1 is my signature. So here nothing mentioned in his opinion, has not given any opinion that what has caused that injury, whether it is a blunt or sharp or any kind of weapons. And the doctor was not cross-examined, Lordship. Then Lordship, PW5, he's also another brother of the appellant, Lordship, Abdul Manan, page 16. I know the accused and I also knew his deceased wife. Her name was Jamila Begum. About 5-6 months ago, one night, I heard a commotion emanating from Jamila Begum's house. I heard Rahima Begum raising alarm. I went there and found Jamila Begum lying dead in her house premises. I noticed blood streamed over the place. The accused is my brother and Rahima Begum is my niece. When I went there, the accused and Sahabuddin were present there. I do not know anything about the incident, nor did the people present there inform me how the incident took place. The police did not record my statement. And here this witness is also declared as hostile. Then cross-examination by the prosecution. It is not a fact that I mentioned before the police that when I heard the alarm, I went to the complainant's house and found Jamila Begum lying dead in the house, and Sahabuddin informed me that due to dispute between their family, the accused killed his wife. It is not a fact that I have stated before the IO that I informed the VDP secretary about the incident. Sahabuddin informed the VDP secretary about the incident. VDP secretary, Lordship, is the PW1. It is not a fact that I know about the incident and I have informed the VDP secretary about the incident. It is not a fact that as the accused is my brother, I have given false evidence to save him. Then examination by the defense. The IO has not interrogated me and I have not given my statement before the IO regarding the incident. So this witness has also has said nothing, Lordship. The next, Lordship, another witness. This is also on hearsay, Lordship, PW6, page 18. I know the accused. I also knew the disease. She died about 8-9 months ago. At that time, in one morning, the victim's daughter came and informed me that her mother died on the previous night. I went to the victim's place at about 8-9 a.m. So that's in the morning and noticed Jamila Begum's body with head injury. I do not know how the victim died. So this witness is also nothing. She knows nothing. Then Lordship, the IO PW7 is at page 19. On 30/11/2015, I was working as in charge officer of the Navia Police Watch Post under Rotabari Police Station. On that day at about 9 a.m., VDP Secretary Muhammad Ali informed me over telephone about killing of wife of the accused by the accused himself. So here, Lordship, there is, here the police say that Muhammad Ali informed me over telephone about killing of wife of the accused by the accused himself. Then accordingly, I made general diary entry number 427 dated 30/11/2015 and rushed immediately to the place of occurrence along with my accompanying staff. At the place of occurrence in the village Sinisimpur in the house of the accused, I found the woman victim lying dead inside the house with injury marks over her body. The accused was also at the place of occurrence as the village persons had apprehended him. So there is no question apprehended because he is there and he has never fled away. The said accused Abdul Sukur is standing in the dock of the court today. Thereafter, I conducted inquest over the dead body in presence of witnesses and prepared an inquest report. Exhibit 4 is the said inquest report, whereon Exhibit 4.1 is my signature. Also recorded the statements of the inquest witnesses. I also recovered one spade and one lathi broken from the place of occurrence as shown by the daughter of the victim as well as the first informant and other witnesses and stated by them to have been used by the accused in killing the deceased. Accordingly, I seized the 2 articles by Exhibit 2, whereon Exhibit 2 is my signature. I prepared the scissor list in presence of witnesses. I also recorded statements of those witnesses. Then I came back to the police patrol post along with the dead body and the accused. At the place of occurrence, I had also prepared sketch map of the same, which I identify as Exhibit 5, whereon Exhibit 5.1 is my signature. Next page. On the same day at around 8:15 p.m., formal first information was submitted by Muhammad Ali, and I forwarded the same to Rotabari Police Station, leading to registration of Rotabari Police Station case number 269 of 2015 under section 302 of the Indian Penal Code. I recorded the statement of the first informant and also sent the dead body to Karimganj Civil Hospital for post-mortem examination. I also recorded the statements of other witnesses. The next day, I forwarded the accused to the court. Material Exhibit 1 is the spade and Material Exhibit 2 is the broken lance seized white Exhibit 2. The witness, Rahima Begum, has stated to me during investigation that on the night of the incident, when she had woken up, she had found her father assaulting her mother, and she was breathing and trembling with fear, and that thereafter she had gone and called her uncle, who after coming had rebuked her father. She had stated to me that her father had killed her mother. Sahabuddin PW3 had stated to me that on the night of the incident, Rahima had come to him and had told him that her father had killed her mother. Abdul Manan PW5 had told me that when on hearing the alarm, he had gone to the house of the accused and had found the deceased Jamila Begum lying dead in the house, and that the prosecution witness number 3 had informed him that due to dispute in the family, the accused had killed his wife. He had also stated to me that he had informed the VDP secretary about the incident. I collected the post-mortem examination report of the victim and submitted charge sheet against the aforesaid accused, which I identify as Exhibit 6, whereon Exhibit 6.1 is my signature. Additional further examination is chief of this witness refers as certified copy of general diary entry mentioned in his testimony is not seen in the case record. Then further examination of PW7. Exhibit 7 is the certified copy of the general diary entry number 427 dated 30/11/2015 of Nibia Police Watch Post under Rattabari Police Station, duly certified by the officer in charge of the Nibia Watch Post, Sri Pradeep Singh, is his signature, which I know. The said entry was made by me on information from DDP, Secretary of Simsimpur, Mohabbat Ali, over telephone about killing of wife of Abdul Sukur by the accused himself, and also that the dead body was lying in the residence of the accused. So here, Lordship, there is different, because here once he said that Mohabbat Ali, that the accused has informed, and whereas in the deposition, Mohabbat Ali has said that Abdul Manan has informed. Then the information leading to the aforesaid general diary entry was received at 9 a.m. Exhibit 7, the phone number of the caller has not been written. In the first information, the fact of the killing of the deceased by use of spade has not been written, even though the use of spade in attacking her has been mentioned. So, not attacking because there is no eyewitnesses then. I had reached the place of occurrence at 11:30 a.m. and I had prepared the Caesar list at 2:45 p.m. The Caesar list does not mention cause of the delay of around 3 hours. On Exhibit 2, I had taken signature of 2 witnesses. I had recorded the statement of the witness Nazimuddin under section 161 of the Code of Criminal Procedure. But this Nazimuddin is not examined. He had not cross-examined. He has not come for deposition, Lordship. He had not made any statement with regard taking place of the incident. I had recorded the statement of the witness Sahabuddin twice, once after taking his signature on Caesar list and the other as a witness to the inquest. On the levels on the material exhibit number 1 and 2, signatures of the witnesses were not taken. On the said levels, the date and time of Caesar has not been mentioned. The statements of the owners of the houses denoted by letters B, C, D in Exhibit 5 was taken, but the statement of one of the inmates of the house denoted by the letter D was recorded. It is not a fact that the materials Exhibit 1 and 2 were not seized in connection with the instant case. It is not a fact that the witness Rahima Begum had not stated to me that the accused had killed his wife. It is not a fact that the witness Sahabuddin had not stated to me that Rahima Begum had informed him that the accused has killed his wife. It is not a fact that the witness Abdul Manan had not stated to me that when on hearing the alarm, he had gone to the house of the accused, he had found the deceased Jamila Begum lying dead in the house, and that the prosecution witness number 3 had informed him that due to dispute in the family, the accused had killed his wife. I had not seized any blood-stained clothes from the place of occurrence. I do not remember if no such clothes were at the place of occurrence. I am not a sub-inspector of police. It is not a fact that legally I am not empowered to file charge sheet in a case of homicide. It is not a fact that I have submitted charge sheet after performed pre-investigation. It is not a fact that no proper seizure was made in this case. And Lordship, here that the 161 and all this has been not been proved, Lordship. And next, Lordship. So, Lordship, we have seen that there is no eyewitnesses, and none of the witnesses has given regarding PW2, 3 and 5, they were declared hostile. So nothing has come out even in the cross also, Lordship. Now, Lordship. Made it 313, Lordship, of this one, page 23. Abdul Sukur, the accused, Lordship, accused appellant here. Question 1. On 29/11/2015 at midnight, you were in your residence with your wife, late Jamila Begum, and your daughter Rahima Begum. What do you have to say on this? It is true. And question 2, at that time, you had a quarrel with your wife, said wife, and you were assaulting her and were shouting at her, and your said daughter had gone out to call Sabuddin, what do you have to say on this? This is not correct. Then question number 3, Lordship. After return from the house of Sabuddin, which is situated on the top of the same tilla on which your house is situated, she had found her mother lying on the ground and you standing near her. At that time, 2-3 neighboring persons had also come to your house, and your daughter had offered water to your wife, and your wife died at around 3 a.m. What do you have to say on this? So he answered, I and my wife were sleeping in different rooms. With my wife, my 2 daughters and 1 son were sleeping. Suddenly, my wife shouted and called me to hurry towards her room in a loud voice. Thereafter, I lit a lamp and went into her room and saw that half of my wife's body was on the bed and half was resting on the floor and that she was bleeding. I tried to ask her as to what had happened to her, but she fell unconscious. Thereafter, I sent my daughter Rahima Begum to the house of my brother Sabuddin and he came. I wanted to take her to hospital and asked my brother to arrange for a conveyance. But he could not arrange and told me that let it be morning, whereafter she would be taken to hospital. Thereafter gave water to my wife and she immediately after taking water, she died. My brother went away, I kept sitting. Then next question. The deceased had suffered cut injuries and was bleeding at time. What do you have to say on this? She had not suffered cut injuries, but she did have bleeding injuries in her head. Then question 5. You had inflicted injuries on the person of the deceased with the help of a spade and 1 lathi, and the police had seized the same from the place of occurrence after being shown by Rahima Begum. What do you have to say on this? The allegation is false. The spade was taken by the police from the cowshed. The same was not shown by my daughter. Question 6. One Abdul Manan of your village had informed the first informant in this case about the incident, and he, the PW1, Muhammad Ali, had seen the dead body of the deceased lying in your house after midnight on the day of the incident. I cannot say if Abdul Manan had informed Muhammad Ali about the incident. However, I had informed Muhammad Ali about the incident. He told me to go back to my residence and stated to me that he would inform the police. Thereafter, the police came and arrested me and forwarded me to court. And question 7. On postmortem, the doctor found 1 incised wound of size 5 into 1.5 inch bone deep over the right frontoparietal region of skull, and the underlying bones were fractured, and the brain matter had come out of her skull. He had also found incised wound of size 2.5 inch into 1 inch bone deep over the left knee joint of the victim. The doctor had further deposed that on postmortem, he had found her membrane ruptured on the right frontoparietal region, laceration of brain matter frontoparietal region, and hemorrhage over the area. He had opined the injuries to be antemortem and the death of the deceased having been caused due to the said injuries. What do you have to say on this? She had fractured bleeding injuries on her head. This is what he replied. Then question 8. Abdul Manan had reached the place of occurrence on hearing cry for help of Rahima Begum and had seen Jamila Begum lying dead in the house. He had seen you and your brother Sabuddin there at that time. What do you have to say on this? This is not true. Only Sabuddin had come. Thereafter, I went to the house of Muhammad Ali. I cannot say if thereafter he had come there. Question 9. The police had conducted inquest over the dead body at the place of occurrence. What do you have to say on this? I cannot say as I was kept in the courtyard. Then question 10. Your daughter had stated to the police that you had killed her mother. What do you have to say? This is not possible as she knows the truth. Then prior to the formal first information, PW1 had informed that the police of the incident leading to making of General Diary entry number 427 dated 30/11/2015 of the Nuclear Police Watch Post. I am not aware of this. Do you have anything to say, Nada? I am innocent. I have been falsely implicated in this case. And do Lordship, he says that PW3 three, Lordship, that has been, question number three, it can be said to be corroborated. Here also the in 3W1, he has stated that seen that his wife was already there bleeding before him only, and that has even here, though PW2 has not stated, but PW3 has stated that she has informed that someone was there in the house. Now, Lordship, may I?
Direct evidence for the.
So why this previous statements of these three witnesses, PW2, PW3, and PW5, are not to be read into the evidence? We'll come back. Previous statements of PW2, PW3, and PW5, because IO has said that IO, who is IO? 7. Seven has said that the witness Rohima Begum has stated to me during investigation that on the night of the incident, when she had woken up, she had found her father assaulting her mother, and she was retching and trembling with fear. And thereafter, she had gone and called her uncle. So, already assaulted, according to the IO.
That has to
And
be proved.
PW2 has said clearly that is what she was put to, she was confronted with that in her testimony, right? After declaring hostile. After declaring hostile, the prosecution has put that statement to her.
Yeah.
And thereafter, IO has said that she had stated in her previous statement like this, mother was assaulted by her father. We'll come back. Be effaced altogether. whatever. he can take. Read the law. Louder. Bit louder.
Lordship, that in contradiction.
Just get a record.
Here the, good highway, but that has not corroborated, Lordship. And still I'm not audible.
Out there. It's not long.
Yes, Lordship.
Yes. Earlier, this mic was not there.
Yes, Lordship. Yes.
Prior to COVID, mic was not there. Everybody was hard.
I think now because
You're
it
the
has
mic.
been used, so our voice has been reduced, Lordship.
Huh? After COVID, voice is reduced.
Because we got used to this mic, Lordship.
Yes.
Lordship, the statement of that is not corroborated, Lord. And also the question to PW that has with a statement and all that was not put to them, though, and they have denied it. And that has
Who?
PW to
Denied. But I
in her
was taken. IO was taken.
IO was taken, but
Was taken to the previous statement.
Yeah.
Page 20.
but the IO statement has to be corroborated by this one PW2. So the IO has stated, PW2 has stated, but here when PW2 has stated, she has not stated.
Okay, she
Yes.
denied.
She denied.
Then IO page 20.
Hmm.
The witness Rohima Begum had stated to me during investigation that on the night of so and so, he had woken up, he had found her father assaulting her mother. How this part?
But it has to be quoted, but that is not there. And also it has to be exhibited part by part, Lordship. That is not there. And also that part has to be exhibited, each part. So that is not there. Cannot, now may I take to the discussions and findings of this one,
How this has been treated by the whether he has accepted this. Sorry.
Lordship, it is in para 9, Lordship.
Yeah.
I read from para 9, Lordship. The investigating officer examined as witness number 7 has stated that on 30/11/2015, he was working as in charge officer of the Nivea Police Nivea Police watch post under Rottabari Police Station, and that on that day, at about 9 a.m., BDP Secretary Mohabbat Ali, the prosecution witness number 1, had informed him over
That is
telephone.
testimony.
And it is here, Lordship. Below, I'm reading from there, para 10, Lordship. I'm reading whole of para 10, it's from here, Lordship. The certified copy of the general diary entry number 427 dated 30/11/2007 shows that the prosecution witness number 1 given the telephonic information to the police that the accused had beaten his wife to death in his house.
Which paragraph you are reading?
From para 10, it is there in para 10, from page 33, Lordship. It is, the whole thing is described in this para, Lordship. Yes. It is here in para 10 only.
No, regarding PW,
Yes.
where he has discussed
His PW,
this part, outside, then
Yeah.
prosecution,
That is,
cross-examination,
it is here,
then
Lordship.
IOs.
Yeah.
Where is it?
Para 5. And witness number 2. Then I'm reading from para 5, Lordship.
Court act. Learn it. Those statements. Right? Now, how the trial court has
Lordship, the full finding is at page 10, Lordship, sorry, para 10, Lordship 33. So everything is discussed in para. Lordship, page 35. But may I read para 10? The section is there in
Right.
Fine.
Prior to the occurrence. After that moment of the occurrence.
After one day. You declare both
was
sides.
right. Get 5 or declared as right. Or it is whether convicted it is the evidence right. Second, based on the evidence of fact.
But one part is
Yes, that part to that extent or to about consistent and photographs with the process.
now. There is that part. What part?
Like if that is
Yeah.
it happened. The accused after with my father, Nabila Begum is about 7 one time. That is to the sound of a phone. Called my father. My father or uncle Subuddin out on top of him. And reached my at that time, what what my
That's all.
and the material part, there is no process of it on the material part and just prior to the occurrence, he has barred the couple. Both are parents,
Maybe.
trimming daughter. Thereafter, her father asked her to call her uncle, who is like of came him. And the proximity of time between she came to call her uncle with house. And she came back with PW number 3. Proximity is very close, doctor. Because at that time he was, then she came back. Doctor.
Time.
No, he has been told by
One
PW
night.
5. Because at the midnight, the occurrence took place at the midnight.
That is also not there.
And trimming was hard by PW 3 and PW 5. At the same time, they have come down.
PW 5.
Yes, doctor, kindly come to page. PW 5 is at page 60.
Yes.
Yes, doctor. While I was sleeping,
had
my
it.
niece Rohima came trimming to my house. My niece Rohima trimming to my house. She informed that somebody entered into her house. Yes. Page
He had.
doctor,
Okay.
my niece Rohima came trimming to my house.
Rima.
Yeah.
But it's not here.
Promotion was
Only
hard by
PW 5.
5. And he has informed the informant that is PW
Now,
1.
nobody has time.
Time is
Only 9.
only 9.
Draw. Regarding property of time. Which are not trial protest law.
Because just prior to the occurrence and just after the occurrence, the victim was ordered with the disease. And he has taken the plea of third person that he has just entered and assaulted. Yes, somebody has assaulted. But there is nothing on record to
Yes.
show
Right? Property of time.
yes. There is nothing on record to show that he has
Where- side
But so far it's PWD.
that
is
here
concerned.
offer. Time factor was not proved. Acceptable.
But the PWD plot, he has categorically stated I was living with my parents.
Oh.
Was there, he has heard the commotion and our statement is corroborated by PW5.
So is the time
Time factor
because the trial court has drawn with proximity of time. Where from? That the wrongly proprietized
Yes.
wrong proprietized is not amounting to your digital doubt.
Not.
And it proved that yes, of you is from the house. And her yes, are they then from there that I have my
Yes, that is
Oh.
not there.
of three at about 12 o'clock. And within 10 minutes, I returned to my house, found my father died. Dead. That is not there.
That is
And at that time, the mother was when she left.
when she by the if her entire position or statement is totally consistent, corroborated by the state.
How?
That can be brought for corroboration.
There is a manner. That manner is not there. But if I, or one,
Rights was cross-examined by the defense. Oh, because there is no accusation put to her defense with regard to how some outsider has attacked her parents. That
alter, alter, money, wife, that will take up.
record to
Right.
show that there is any practicality.
If I they would invite something and altering and by itself and declared a side and it's not required. Why they should actually they confine their procedure within the barest minimum. Iowa's thorough process. Iowa's but they decided not to enter into an media process. And that
Take the circumstance,
we limited
not if thing is that uh, corroborated by PW 5, 3, 5 and 2 or regarding
and there is some probability.
Yes.
Whether that is up to being of a Could you put the statement under Yes. Yeah. if duly proved? Has to be proved. I guess
Five. Although direct evidence
it's both of
for that he has in his examination chief has stated that
But-
there will be I heard a common message from the Vietnamese house. I heard study basic around. I went there and found that I not been of this the cute and brother because they come here like the hub presented.
Sabuddin was already there.
Al-
So it was not the first that I
Well, lordship, look in her deposition at page 11, she has stated at that time midnight. Two, three people already arrived. When I returned, I saw my mother lying on the ground and my father was standing. At that time of midnight, three people arrived. The fight pretty arrived before stop. We took the fight. We took the fight. We took the one. And on the basis of committed count, we took the fight. We took the contest, made a telephonic information to the police. To that extent, we get the
it is here.
Lord.
Here.
He has
Not
come
a-
to occurrence now. Thereafter, he has come to occurrence. He has seen what to come to work, I think come to I come page 58. The GK entry. Deputy Secretary Mohammed Ali informed over phone that in the previous night his co-villager Abdul Tukur killed his wife by assault. PW three state for the and study. 13. I was sleeping, my niece Rohima came living to my house. No, not PW1. Try to complete page 9. I know the case from our village about 6-7 months ago. One morning at about 8 a.m. Abdul Mannan from our village came to me and informed me that the accused is previous. I immediately went to the accused person. I saw the body of the victim. There was a head injured with glass. Victim was lying there. I informed the Ratnabari police. Thereafter, he has first had been refer one judgment. Would have eleven February.
His cross examination. W2, W5, all were cross examined, but they were not contradicted. Cross examination is one part, but contradiction, without contradiction is another part. It's not done. So that part goes. Whatever image. It's not contradiction. But they have
Lordship. Legal aid counsel, Lordship, appointed as amicus in the court, Lordship. Lordship has fixed it on
Yeah.